5, 4, 3, 2, 1, start. In this backdrop, useful reference can be made to the decision rendered by this court in Ramcharan Singh and another versus Gurdwara Sri Kartar Sabha, wherein a distinction was made with regard to the observations made by the Honorable Delhi High Court in Kiran Singh's case (Supra), which related to the suit filed by the plaintiff for mandatory injunction directing the defendant to quit and vacate the workshop in dispute. Full stop. The plaintiff was landlord of the suit property and the defendant was a licensee to run the workshop. Full stop. The suit was decreed before learned trial court. Full stop. First appeal filed by the defendant was dismissed and second appeal was also dismissed by the court. Full stop. When the plaintiff filed execution petition, the court ordered delivery and issued delivery warrants. Full stop. Challenging the said order, revision petition was filed and while disposing of the revision petition, it was held that when the decree is not for delivery of possession, nor the decree holder adjudged his entitlement to receive the possession, provisions of Order 21 Rule 35 CPC are not attracted. Full stop. Stanza. The decree holder can only invoke Order 21 Rule 32 CPC for detaining the judgment debtor in civil prison or attaching and selling his property or both. Full stop. It was observed that where a party is content to seek decree for injunction to vacate rather than delivery of possession in a suit properly framed for the purpose, he has to face its logical consequences and he can have the decree executed only in accordance with provisions of law governing execution of decree for injunction, and he cannot employ the argument of frustration of his object existing behind his suit to obtain a relief from the court which was not envisaged by the suit and not granted by the court. Full stop. Stanza. On the other hand, learned counsel for the respondent, decree holder, plaintiff has assiduously submitted that where mandatory directions have been issued for vacating the premises, no other interpretation except that possession has to be handed over could be put on such a decree. Full stop. Rather, learned counsel has made reference to the judgment under execution and pinpointed that a specific direction has been given to the defendant to hand over the vacant possession of the half portion of the house allegedly lying in his possession. Full stop. It is submitted that revision petition has been filed solely to gain time to raise obstruction vis-a-vis execution of the judgment passed by the court against the petitioner. Full stop. Stanza. Admittedly, the respondent had filed a suit for mandatory injunction for seeking direction to the petitioner to vacate and hand over the possession of the suit property as detailed in the decree sheet which has been placed on the court file, and also sought relief of permanent injunction and recovery of arrears of mean profits at the rate of rupees 1,500 per month for the use and occupation of the premises in question from 9/9/2007 till the possession is handed over to the plaintiff. Full stop. Undisputedly, the suit was decreed by the court by judgment dated 9 March 2014. Full stop. Nothing as such is coming forth on the record about the said judgment having been challenged any further. Full stop. It is pertinent to mention that as evident from the aforesaid judgment, the suit property was initially ownership of Dinesh, who had executed gift deed dated 14 April 1990 in favor of one of his sons, namely Ravi Singh, who is brother of the petitioner, full stop stanza. The petitioner, being brother of Ravi Singh, was also having possession of two rooms, one kitchen and one bathroom towards the side of the house where he was residing with his family, and the residue portion of the house was in possession of Ravi Singh. Full stop. Said Ravi Singh had executed a sale deed dated 29 April 2006 in favor of Kanhaiya Lal. Full stop. The respondent plaintiff had made a request to the petitioner defendant to vacate the property and hand over the vacant possession of the half portion of the house, as his license to use the said property had already been terminated with the service of notice dated 21 August 2007. Full stop. In the written statement, the gift deed dated 14 April 1990 allegedly executed by Dinesh in favor of Ravi Singh, and subsequent sale deed dated 29 April 2006 in favor of Kanhaiya Lal with regard to whole of the house was asserted to be illegal. Full stop. In the judgment under execution, on appraisal of the evidence brought on record, and also considering the fact of the gift deed having been challenged by Karam Singh in another suit which had since attained finality, it was held that the gift deed was executed by Dinesh in favor of his son Ravi Singh, and on that basis Dinesh had ownership right over whole of the suit property, and thus in pursuance of sale deed having executed in favor of Kanhaiya Lal, he had stepped into the shoes of owner. Full stop stanza. The suit filed by the present petitioner against Kuldeep Singh to challenge the legality and validity of the gift deed and the subsequent sale deed is bearing CS number 70/2007, wherein white judgment dated 26 February 2011, the claim of the petitioner with regard to his right claimed in the suit property was declined. Full stop. The said suit was further challenged in appeal, and by virtue of judgment dated 7 December 2014, the appeal was also dismissed. Full stop. Considering the aforesaid facts, the suit filed by Christian Lal, subsequent purchaser for mandatory and permanent injunction as such, was decreed. Full stop stanza. It is in view of the aforementioned historical perspective that the order dated 22 February 2003 passed by the civil judge has to be examined. Full stop. The expression act required to be done has been extended to prohibitory as well as mandatory injunctions. Full stop. The view taken by the full bench of Delhi High Court has been treated as a narrower view because that was a case in which the decree against the licensee was to quit and vacate the premises, but the High Court, by taking a narrower view, expressed its inability to invoke Order 21, Rule 32. Full stop. Therefore, the question posed by the Law Commission, which led to the recommendation for adopting wider view, has been accepted by inserting explanation to Sub-Rule 5. Full stop. The decree holder is not required to file another suit when he has already acquired a decree in his favor by spending much time and expense. Full stop. The court therefore would be fully competent to direct that the act required to be done may be done so far as practicable either by the decree holder himself or by some other person appointed by the court at the cost of judgment debtor. Full stop stanza. In the instant execution of the decree for mandatory injunction where the possession is sought from a licensee, the aforesaid order is consistent with the spirit of law, and the explanation added as per the recommendation made by the Law Commission. Full stop. The direction to vacate the premises situated in the Gurdwara Sahib where the judgment debtor petitioners were allowed to stay, being the Sevadars in another form, and method to direct handover of possession full stop. It can mean nothing else except the handing over of possession, and therefore the wider view as suggested by the Law Commission has to be followed because it serves the ends of justice full stop. The decree cannot be defeated by raising technical objections full stop. It is well settled that technicalities of law should be construed to advance justice and not to defeat justice full stop.